Hi, my name is Amina Zara and I'm an intern at Khatana's Law Chamber. Today I have the privilege of speaking with Mr. Basim. He is an esteemed advocate and a renowned figure from Khatana's Law Chamber. With extensive experience representing Pakistan in international law and trade, he has made significant contributions to his field. And today I will explore his insights and his accomplishments in this interview. Thank you very much, sir, for taking our time for this interview.
You're most welcome.
Before we go into the main discussion area, sir, can you tell me about your journey to becoming a lawyer? What made you pursue law?
Okay, so basically, I've seen people, they've got role models, they've got a long-term professional plan to pursue law. For me, it was quite different. I had only one passion, and that one passion was for debating, and debating with rationale. And again, arguing with rationale. So I used to think about it that what profession could fulfill my passion towards arguing with rationale, and it was the degree of law. And that is how the journey started, and here we are.
The rest is history.
Yeah, absolutely.
Given your expertise in child custody and family law, I will now turn our discussion towards that topic. The best interests of a child are paramount in child custody cases. Can you tell me about how Pakistan law recognizes and prioritizes the best interests of child in child custody dispute cases?
All right, so for answering this, we need to look at the Guardians and Ward Act 1890, and specifically, while answering your question, it is the Section 17. See, when we are talking about the paramount consideration or child custody, you need to understand that it is not a mathematical equation. We need to understand there are a lot of ingredients which needs to be looked into one bottle. So starting up with, when we talk about the Section 17, it enables and it note down the basically the basic ingredients for a guardian to hold. And the number one ingredient is the welfare of the minor, which includes education, health, security, safety, and psychological enhancement. We also need to see the international law, the things which are common between Section 17 and the guidelines given under United Nations rules for the child custody are pretty much the same. Whenever we talk about child custody, what we need to understand is the law was derived from the Section 17 from the Guardians and Ward Act. But till now, as we have seen with the time, I'll share a few judgments with you and I'll note them out. 2018 YLR 1730, 1974 SCMR 305, and 1978 SCMR 299. These are the judgments. So basically the act is from 1890. But these are a few latest judgments which derives that even till today, when a judge or a court is deciding a child custody, the paramount consideration is child's health, child's education, physical and mental health, psychological development, and emotional well-being. So it is not that one of the guardian or one of the proposed guardian is fulfilling has to fulfill each ingredient. Even if the proposed guardian is fulfilling, for example, 3 ingredients out of 5, he's not a prescribed guardian. He has to fulfill all the ingredients available in Section 17 and guidelines given under international law.
And all 5 of these cover the child's welfare?
Absolutely. And these are again penned down in the certain judgments I've mentioned.
Okay. Could you walk us through the typical legal process for resolving child custody disputes?
So basically, so it's kind of a mirror image of the civil procedure. So you file a petition, and once the petition is filed, you go for the, of course, the other party has the right to give the written submissions. Could be written arguments later, but it should be the written reply first. Then you have the right to produce the evidence. Now that is one point which has great importance. In civil cases or in other cases, there is a point where people pen down the evidence through documents. But specifically in child custody, you have to go through a lot. So it starts with, if the child is with a certain proposed guardian, he has to prove that he is fulfilling all these 5 elements which we have discussed. And to prove all of these 5 elements, they have to produce the documents. So when we talk about child's health, so imagine if a child is like 6 years old or 7-year-old, the proposed guardian should always file all the vaccination forms, all the visits to the doctors are documented. So all of those kind of documentation should be in front of the court, as well as the result cards, receipts, fee receipts, and any other extracurricular activity. So basically the documents should always revolve around all of these 5 elements in the evidence stage. Then it comes to cross-examination. Of course, we can, we can assume that a proposed guardian has submitted a fake document. That is the point. The other proposed guardian, or the guardian who wants, or the other proposed guardian who actually wants the custody of the minor, can actually claim that the other party is misleading the court, and that is where our cross-examination comes. Once we are done with the examiner-in-chief and cross-examination, then comes the final arguments. And once the final arguments are done, again, in determination of these elements, the court has to decide in the interest of both the parties.
Okay. From what I understand so far, it can be complex to navigate through these child custody dispute cases. So do you have any advice for parents, how they can protect their rights and prepare for this legal process?
Okay, so being a lawyer, I would tell one thing, and that's a bitter reality. Even if you're a mother or a father or a grandparent, remember one thing: whenever you file a custody or you're into the court and through the litigation, whether you win a case or lose a case, remember always the loser is the child, because there are certain reasons to it. For the sake of argument, maybe the proposed guardian should be the mother, or maybe the proposed guardian should be the father. But from the lens of a child or a minor, he or she actually needs love and affection of both. But of course, that all depends. If one of the parent or a proposed person is a security threat to that minor or does not keep any of the ingredient of it, of course he or she does not deserve the custody. Even for that matter, one party always gets a custody, but the other party gets the visitation right. So again, whenever I say that the minor is a loser, is because in the court you get the success that, oh, I got the custody, or the other parties have got the visitation rights. But for a minor, it is a great hassle, and mentally it is not acceptable that just to meet your own parents, you have to go to the court or the guardian room where there are plenty of bailiffs. You see there's a lot of lady police, and you see a lot of court staff. So for a minor of age of 6-7 years, it does not create a great impact on the mental health of the minor. One more thing, the courts have improved. Like, they've got television, they've got some cartoons and stuff like that. They've got some kind of snacks for children in the guardian room. But the ultimate truth is that those guardian rooms are existing in the courts. And a child who is visiting a court like thrice a week or once a week or once a month, it would never bring a great impact on the mental health of that minor.
Do you have any special case or project that you worked on? Can you tell us about it and what made it significant?
Yes, so it's a very pertinent question, and I appreciate that. So first of all, there was a very important case, and I'll take you back to the cross-examination and evidence stage. Again, I would, of course, for the privacy matter, I wouldn't name the case or the judge or the court or specific evidence, but what happened was, and it's also a lesson for all the young lawyers, we had some receipts from the school. So those receipts were there to try to prove that the minor is studying in the school. So we were representing a grandfather, maternal grandfather. And to look into it, the father who had the actual custody of the minor and the mother of the minor has died already. So that father submitted those receipts in the court. So it was for us, because when it is in front of the court and we do not confront any evidence, it is acceptable. So it was for us that we scrutinized all of that documents, and astonishingly, one of the receipt back in like 2021 or 2022, we went into the calendar, and one of the receipt was issued on the day of Sunday. While in the while in the cross-examination, when we asked the other party that what are the working days of school, those were Monday to Saturday. So if the receipt was issued on Sunday, it was merely fake. If not fake, it raises a question over the entire trial or the evidence submitted by the party A. So examination of the documents is very, very important, and that was one astonishing and very important case of ours that I feel that had turned the tables around at the last moment when we got to know that the receipt was not so authentic.
Thank you. That was very informative. For our next area, I will turn towards advocacy skills because you have expertise in that area. Can you tell me about how you developed your advocacy skills throughout your career? Are there any specific techniques or strategies you find particularly effective? Okay,
so there's a technique that you'll hear from every lawyer, and I would also suggest that technique, but in a different manner. There are 3 ingredients, and there was a Latin term, know thy judge, know thy facts, and know thy law. That means you should know on a lighter note, when we talk about know thy judge, it does not mean like what kind of a coffee the judge likes. It's about what kind of arguments the judge likes. There are some judges, they go straight on the facts of the case. There are judges, they go straight on the law.
You work your way around the judge?
So basically, as a young lawyer, I would suggest whenever your case is fixed in a certain case, in a certain court, I would highly recommend that prior to that case date, like for a day or two, you should sit in that court and observe what the judge wants from the lawyer. It always helps. And then it is facts, and then it is law. So the combination. So people ask me that we lose confidence when we are on the roster, or when we are in the front, when we are in the front of the judge. My take on this is confidence comes with only one thing, and that is preparation of the file. The more preparation you have, the more grip you have over your file, the more better you'll perform in the court. So again, it's a match. You have to combine the facts, and the facts are basically the person who has the greatest knowledge of the facts is your client. But after first or second client conferencing, you should know the facts better than your client. Once you have the facts, of course you know the law better than your client. When you combine the law and your facts and you make one defense line, that till the end of the case, this is my defense line. That is very important, to create a defense line. Once your defense line is created and you know the law, you know the facts, you can assist the judge. Your file is prepared very well, you have the skeleton arguments, you have your written submissions. And again, you know where the judge will go. If the judge goes towards the facts straight, you have your facts with you. If the judge goes with the laws, for example, if you're pursuing with a custody case, right? You have the facts, but when it comes to the law, you have to navigate the judge through section 17. Then you will discuss all of these 5 ingredients. So whatever we have discussed is law. And then, of course, Pakistan follows binding precedent. So of course, if you're arguing a case before a sessions court or a family guardian court, all of the judgments of the high courts and supreme courts, they are bound. The lower courts are bound. So of course, you'll find all the judgments which navigate all of these 5 ingredients. So you have the facts, you have prepared your case, you know the law. So the law is section 17. The facts are that for example, that the minor is with his father, but factually the father is also a murderer of the minor's mother. So these are the facts. So you know the facts, you've applied the law that if the minor is residing with a person who is involved or who is assumed to be involved in a murder, may deprive the child from all of these ingredients. So these are your facts. You're combining it with the law, and again, you know the judge that if the judge wants the facts first or the law first, you combine that case in a way and just present it. So people always complicate it. Like you'll get to know that stare yourself in a mirror and argue a case before going to the court and so on. So again, I think these things may work or may not work, but for me, there's only one thing. If you have grip over your file, you have your preparation done well, the advocacy will comes itself.
You've already went through it, but since we're focusing on how important preparation is for effectively advocating for your client, can you tell me how you prepare for a case, from the advocacy perspective?
Right. So it takes 2 personalities of yourself. The first personality is you should be a good listener. If you're a good listener, you'll grasp the facts very quickly. If you're not a quick listener, you may not. When a client comes in, the client has, to be honest, the client may say 80% of the things which do not matter. But even then you have to listen to it, because there might be a certain point coming from all of those things which do not matter. There may come a point which actually matters and which may make you win the case.
And you should be noting down everything.
Yes, you should. Yes, you should. In a client conferencing, what I do is I take notes of every point coming from the client, and instant thing which is going inside my mind, I note it down. So the first part is you need to be a good listener. Once you're done with that, the client is gone. You'll absorb all these facts and you'll do your job. Then the lawyer comes in, and that lawyer will absorb all the facts and it will combine with the law. And then you will prepare one defense line. One defense line is so important. People at their younger stage, they basically are very reluctant and they struggle about evidence, cross-examination. From day one, once your defense line is clear, that defense line will automatically navigate every procedure of the court towards your case. So basically, if I do not know my defense line, I may ask silly questions in cross-examination, but once my defense line is clear that what is my defense, all of my questions would automatically would synchronize with my defense line, which would ultimately benefit my case.
And you focus it on one area, like this is the area I'm working my defense around?
You need to always have plan A, B, and C, of course. But again, so preparing a defense line is not that I'm promoting or I'm talking about any kind of a frivolous litigation or any kind of a frivolous idea. My point is that to keep in mind if I'm appearing in a child custody case, if my defense line revolves around child's education, I have certain type of evidence that the other person is not maintaining the welfare of the minor and has not admitted the minor in the school. But at the last moment, if there is some kind of a document which proves that he is doing so, so I actually need to have a plan B or C, not in a negative manner, but to keep in mind the welfare of the minor. I should have also researched and pinpoint all of those points too. So the basic crux is not to rely on one point. Make your case to the fullest. You don't restrict yourself to one point.
Alright, this was again very informative. I would like to conclude my interview by asking you if you have any advice for young or aspiring lawyers and the ones that are just starting their careers.
Okay, the problem is, again, in your initial years, the greatest problem is that people complain that we are not financially doing so well. We are not getting certain cases, we are not getting a certain amount of salaries or fee. I always tell them to question yourself. You are complaining that you're not getting a case. Question yourself at this stage. A client comes in, hypothetically gives you 1 million rupees and tells you to file the case tomorrow. Ask yourself, do a self-accountability, can you represent the case? The answer is no. So the first key is, and the basic key is, without looking into any other thing, serve and give your first 3 years just to learn the procedure and observe. That observation and learning of the procedure will take you a long way.
Thank you so much, sir. It was an honor to
You're
interview
welcome.
you. This was very informative and will provide guidance to a lot of people. Thank you for your time and for your insights.
You're most welcome.